Mr. Caruso. Mr. Caruso is, well, he's not like the kids over at the Welsh News Network. He's not a.
I told you. No. No. I told you I wanted to vacuum and dust this room. No. Get out.
Hang on 1 second.
Freaking love that clip.
Well, he's not like the kids over at the Welsh News Network. He's not a.
I told you. No. No. I told you I wanted to vacuum and dust this room. No. Get out.
Hang on 1 second.
Good morning, good evening, good afternoon. I had a hankering for pizza last night, and so on my way home from work, I left the office about 6:45. I stopped by a Little Caesars Pizza, and another YouTuber who I watched had mentioned they're actually pretty good as long as you don't get one of their pre-made ones. And so I got there and I ordered pizza, and they made it hot and fresh for me, and got home, opened it up, and there was no flavor to it. I actually thought I was coming down with COVID, because there's literally no flavor to this pizza. It just tasted like cardboard. And I'm like, man, it's like $10. I'm like, man, I can't believe how like pepperoni and cheese and sauce doesn't have any flavor to it. So tonight I went to Round Table because I just couldn't eat that Little Caesars. It was just disgusting. And I got a double pepperoni with heavy sauce, extra sauce. Amazing, delicious. And yeah, so I'm not going to be sleeping anytime soon. So there was a hearing on Turtle Boy. His I don't know if you all remember, but he had his bond, his bail, his own recognizance revoked because of the arrest for the intimidation of the new witness, the very unbelievable gal who he got into a DV situation with. Well, the 90 days is apparently up. It doesn't feel like it's been 90 days, but I guess we're darn close to it. It's the 23rd. He must have had his bail or bond revoked somewhere around, what was it, like the day after Christmas, like the 26th or something. So here we are, live court hearing today. Just caveat, I was listening to it live for up to when Bradel started speaking, but we'll go through it again, and I can tell you, I guess, what I was listening to and what I was hearing.
Yes, literally.
Board, all right. This court is now back in session. Please make sure all the cell phones and electronic devices are turned off and put away, please.
Thank you, officer. Thank you, everyone, and good afternoon, Mr. Clerk.
Good afternoon, Your Honor. This is 23-313 as well as 2443, the Commonwealth versus Aiden Kearney. Can I have counsel identify themselves starting with the Commonwealth?
Certainly. Good afternoon, Your Honor. My name is Robert Novak. I'm Special Assistant Attorney General. I'm filling in for Mr. Mello, who's ill.
All right, Mr. Novak, good afternoon. Welcome.
Hello, Your Honor. Timothy Bradel on behalf of Aiden Carney. Before me, Judge, in custody for the record is my client, Aiden Carney.
Good afternoon, Attorney Bradel. Mr. Carney, good afternoon. Welcome to you as well.
Good afternoon.
Thank you.
All right, so we're here. I believe we're here because
Employment and labor law. Employment and labor law isn't the best thing to have going on there. I don't know why. I don't know why they're picking these guys. I would assume that if they're doing a special prosecutor or assistant special prosecutor, that they would pick someone with, if not extensive, at least a good amount of criminal defense or prosecution experience.
Because the bail revocation period is up, we need to address that. Mr. Bradel, there are also 2 new indictments against your client. Do you wish to have him arraigned today?
I do, Your Honor. Thank you for.
All right.
I appreciate
So let's do that first, Mr. Clerk, and then we'll deal with issues relating to bail thereafter. All right?
Thank you, Your Honor. Mr. Bradel, does your client waive the right to a formal reading of these indictments?
Yes, we do.
One count of intimidation of a witness, one count of disclosing the contents of a wiretap. Mr. King, how do you wish to plead, guilty or not guilty?
Not guilty.
Thank you. You can have a seat. Question of bail, both cases.
Yes, Your Honor. The
Go ahead.
Commonwealth would be requesting $10,000 in cash bail in certain conditions. The first one being that the defendant stay away from the alleged victim in the case. Secondly, that he obey all outstanding restraining orders regarding the victim. And thirdly, requesting that there be a GPS monitoring with just an exclusion zone as to the victim's home, place of work, or schools that her children may attend.
All right.
So what's weird to me is why Mello and this other guy are proceeding down this path. Cash bail in Massachusetts, and my understanding may be off, but this is my understanding as a first-year family law attorney out of California. Cash bail is different than a bail bond. Cash bail is like you have to put, like, if it was $10,000, you have to actually put $10,000 in cash. Basically, you hand it over to the court, and the court will give that back to you, provided you don't fail to appear. And which is different than just a bond amount, which is where the court would say, like, it's $100,000 bond, and you go to a bail bondsman and you pay the money to the bail bondsman to buy the bond, and the bail bondsman would put the money with the court. So it's a different thing slightly. I mean, it's where you or someone has to put up the cash directly instead of a bail bondsman. So it's a little more and another difference is if you don't appear, you forfeit the money. Whereas with the bond company, if they could get you in there, then they can get their bond back. That's my understanding of it. Again, I don't practice law in Massachusetts. But the purpose of bail and bond is to get the money part, the dollars, is to secure the appearance of the defendant at the next hearing, or at all the hearings, I guess, until trial. That's the purpose of it. It's not to punish the defendant. It's basically they want to make sure the defendant appears, and so the court's going to look at a lot of factors like if the person's dangerous, if the person is likely to abscond, if they have family that lives in the area that's going to make it less likely that they're going to leave. If they own land, like a house in the area, it's going to be less likely they're just going to pick up and walk away. They're going to look at the criminal history of the person. They're going to look at all these factors to try to make an educated guess on how likely it is that person is going to just up and bounce and not appear. The kind of default in Massachusetts, again, if I understand Massachusetts law correctly, and again, I am not licensed to practice in Massachusetts, the default is personal recognizance. So unless there is a likelihood that you're going to bounce, then it's personal recognizance. So I don't know why the state, in this case, the special prosecutors, are asking for a cash bail. That I have not seen anything that would lead me to believe that Turtle Boy is going to up and bounce. He's got a family there. His parents live in the area, apparently. His kids live there. He owns a home there with his wife. He's got a business that revolves around Massachusetts gossip. It doesn't make sense to me why they would ask for the cash bail, but they did. And then the other things, like to stay away from the witnesses. As far as the one witness who he last apparently engaged in witness intimidation with right before Christmas, his, I don't know if you'd call it girlfriend or fuck buddy or whatever. There's already a domestic violence restraining order between them. So why would you need it to be a condition of bail? And he hasn't done anything that I am aware of to the other witnesses since I know there's a lot of allegations about him like stoking up, but I mean, unless you could show something directly, like where he, said, go do this, then it's a lot of this is just conjecture, but he hasn't like personally, to my knowledge, gone to any of the witnesses since he's been arrested for it or indicted for it or what have you. So I don't know where they're coming from on this personally. Now I'm not a conspiracy theorist. It might just be prosecutors who aren't very competent because it's not their modus operandi. It's not their normal job. It's not what they normally do. So they might be a little bit of fish out of water trying to emulate what they've seen prosecutors do, but not really understanding why the prosecutors did it or the factors that led the prosecutors to ask for it, etc. So it just seems weird. But at least this guy isn't a family law attorney like Mello is.
There are a number of different victims in connection with both matters, correct?
Yes.
So you're asking for a stay away, no contact with all named?
Yes.
Okay.
Yes.
And the GPS exclusion zone would relate to all as well?
Yes, it's not required, obviously, to keep the defendant in the home or just away from the particular victims in the many cases.
How many separate victims do we have? I haven't gone through and identified
I thought
them.
there were like 8.
Okay.
Correct.
All right. Okay. And why is the Commonwealth requesting cash bail as well?
The reason that we're asking for cash bail, Your Honor, is because the new charges are exceedingly troublesome. The defendant has...
The charges are troublesome. Yeah, they're crimes. Crimes are usually troublesome. Like he's saying nothing.
Already been charged with the multiple counts of intimidating a witness, there is considerable. It's obviously that he has a proclivity for continuing in this conduct. If I could go over a little bit of the background of the intimidation, the new intimidation of a witness case, Your Honor. This occurred on December 23rd of 2023 at the apartment of the alleged victim, who was Lindsay Gattani, excuse me. When the defendant came over knowing and for the purpose, because she had received a summons to appear before the grand jury. When he appeared at her apartment, he told her in no uncertain terms that when she went to the grand jury, she was going to tell them that she knew nothing about the case. He further told her that he wanted to take her phone and go through it to look for and to erase any particular contacts and data that she might have regarding the matter.
Okay.
He threatened her in saying that if she didn't cooperate, he would destroy her in front of her kids by publishing old probate court records that he had acquired. The second charge under what we call, I guess, the wiretap statute is that at that same time he recorded their conversation unknown to her and without her permission. The first time she found out about that she was being recorded is when it was published on his website, and then found out that the conversation that was published on the website was not the conversation that she had with him, that it had been altered. Since that time, the police have received a copy of a recording that does reflect what was said, which indicates that she did not consent to the recording. So, Your Honor, the reason that we're looking for bail is obviously the charges are serious. The intimidation charge is a felony.
Notice he hasn't said anything about Turtle Boy absconding.
It carries up to 10 years imprisonment. The wiretap up to 5 years imprisonment. It's clear that the defendant has the proclivity for continuing with intimidation even after being charged and being on personal recognizance for this. And we think the bail and the stay away and the monitoring is necessary just to ensure the safety and protection of the witnesses, at least until the trial.
The safety? I don't know. Safety? He threatened to release documents, but I mean, safety?
Of Karen Reed can take place, and that to preserve justice and prevent it from being obstructed. So those are our reasons, Your Honor.
All right. Thank you very much, Mr. Novak. Attorney Bradel.
Thank you, Your Honor. Your Honor, just some particulars. Mr. Carney's 42 years old, Your Honor. He has two children, ages 6 and 8. He was an 11-year.
He's older, less likely to run. He has two children, less likely to run. Bradel seems like he's been down this road before, and he knows what to argue. Well, I listened to a very sarcastic, shitty-toned reading of the letter from Turtle Boy's mother to the court. And we all need to remember that however you feel about Turtle Boy is her son. And mothers are going to love their children. And I thought it was pretty disrespectful the way Kate had that letter read. And from my understanding, I don't really remember the words that were said in it. But my memory is that Turtle Boy's mother has some sort of cancer or something like that she's fighting right now. And, maybe she doesn't really want to have the stress of knowing that her son's in jail while she's going through this and being able to have her family with her. And these are things that the court would consider, like seriously consider, no matter how derogatorily Kate likes to put it down. These are the things that a court would consider. And I just want to point out again, the prosecution didn't have shit. They didn't really address many of the merit. I think they were trying to make an argument that he's dangerous, but the danger was that he was likely to release documents. If that's the most dangerous thing you could say about someone, you know what I mean? So I don't know. I don't think it's really cool to like shit on his mom. You know, she seems like she's going through a lot, and I don't know if she's a good person, bad person, or otherwise. You know, but she's his mom. You know, let her. It's funny how no one. It's funny how no one wants their. No one wants their own family drawn into anything. It's just fascinating how no one wants their family brought into it. And everybody is so willing to bring families of the people they dislike into it. I don't like you, therefore I'm going to like shit on your mom and things like that. It's fascinating. Human behavior is fascinating.
Veteran of the Dudley Regional School District as a history teacher. And
he's a veteran of the school district as a history teacher. How bad is that school district that you have to be a veteran of it?
As you know, Mr. Carney now operates several websites and news sites that he engages in very prolifically. And
I guess somebody subbed to this guy's stream.
Provides all sorts of investigative reporting to the public and to his many followers that he has. And I just would note, Judge, that he's got a courtroom full of supporters here who think very highly of him and appreciate very much all of his activism and protest and journalism. So that's his current occupation, Your Honor. With respect to these two charges, Judge, this case was the subject of an order from Judge Krupp on the initial bail determination of personal recognizance with no terms whatsoever. Judge Krupp obviously was confronted with the very same issues, the same Norman issues, Como versus Norman issues, and he did not do anything whatsoever with respect.
Bradel came prepared. This is the most prepared I've seen Bradel. Now, if Bradel doesn't fuck it, well, I already know that Bradel wins, but oh, don't fuck it up, Bradel. Like, be a good attorney. I don't care which side you're on. Just be a good attorney.
Back to any stay away orders. In this particular case, Judge, there are complicating factors with respect to what might otherwise be an order in another case. Here you have a journalist who is practicing his craft and is protected by the First Amendment, Judge. And if the court were to adopt the government's request wholesale, there'd be a problem with respect to him being able to cover his topics, which is the Karen Reed murder case. What would happen, Judge, is that anytime any of these witnesses decided to go and attend the Karen Reed murder case, they would essentially have a veto power over Mr. Carney covering the case. So that was raised in front of Judge Krupp, and ultimately Judge Krupp at the
well, you know, Jimmy, you don't like it. I don't. Let's be fair. I don't like his style of journalism either. I don't watch the guy's stuff. The few times that I've attempted to go to his website, it's a minefield of ads. It's poorly laid out. He has random images stuck in places like screenshots of text messages and things. It's certainly not as professional as one would expect from someone who makes their living doing it. And the topics that he covers are very vulgar topics. and you might not think that they're worth reporting on, but there's obviously an audience for it. He provides news coverage for, I mean, the Karen Reed case is news. Like you can't dance around the fact that the Karen Reed case is news, and he is covering it. Like I don't know what definition of journalist you have, but I mean, he's a journalist, bro. Like he might not be a good one, but he's a journalist, you know? I'd be like, hey, journalist, shit journalist, or something like that, but he's a journalist.
The arraignment, not at the bail appeal, but at the arraignment, Judge Krupp erased any restrictions whatsoever.
Mr. Bradel, with respect to the 8 or 9, I think it's 9 with the new indictment, Mr. Novak, witnesses that Mr. Carney is alleged to have intimidated or interfered with, are there any restraining orders in effect?
No, Judge. In fact, 2 of the complainants tried to.
There is a restraining order currently in effect. For one of them, the new one, there's a domestic violence restraining order.
Seek a criminal harassment order in the Stoughton District Court.
I mean a 250-AD?
A 250-AD order, yes, Judge.
Okay.
Thank you. And they were both denied on First Amendment grounds. That was one by Judge O'Malley at the time, one by Judge Walsh.
What about Ms. Gattani, who I understand is the alleged victim in another district court matter?
Yes, that's correct, Your Honor. And
she has a restraining order?
She has a restraining order that's in effect for a year. And in terms of that case, Your Honor, Judge McCallum in the district court set a personal recognizance bail on that case, this new case that we're arraigning now that's been brought to Superior Court. And I know the court's well aware, you know, just the mere fact of an indictment is not a grounds for an increase in bail, just because the government has unilaterally decided to put him in another court. It's the same case. In fact, it's actually a little bit better in the defense category. I provided one of these to the Commonwealth, and it's come to our attention that the complainant who's gone to court and gotten a restraining order saying she's afraid of Mr. Carney, doesn't want any contact with him. This morning at 1:55 a.m., she called him.
I told you that fucking bitch was not believable. Like I believe that Aiden threatened to release those DCF, whatever. I believe he threatened to release those, but I don't believe that he assaulted her, like actually like physically touched her. And
she should know that he's incarcerated, and obviously he did not speak with her at all because he's incarcerated, but she called him on a Facebook Messenger video call at 1:55 a.m. No one spoke with her.
She was probably drunk and missing the dick, like he says.
We have custody of his phone, and we've screenshotted and memorialized that call. So this is someone who, on the one hand, is claiming one thing, and incidentally, factually, Judge, every single factual allegation here, Mr. Carney absolutely denies 100%. And in fact, a lot of it is contradicted by the written record that will come to light. And
this motherfucker had to insert himself. Come on, dude. Let me catch your video without let me catch your video without you listening to you type like an idiot.
And it's been provided in the lower court, the text record where Ms. Gattani contradicts her later statement to the police is contradicted by her text record, where she invites Mr. Carney over. She uses this new case where she's received a subpoena to lure Mr. Carney over, and like moth to a flame, like a journalist to a new set of facts, he went over there to at her invitation to look at everything that had been arrayed against him. Perfectly normal.
Mr. Bradel came ready. He's nailing it right now. This is good lawyering. Whether you like Aiden or dislike Aiden, this is good lawyering. He's making a good argument.
Human impulse to go want to see what people are saying about you, and he followed her invitation to go over there. So that's how the facts of that are going to show.
All right. Do you have a copy of that, Mr. Novak?
I did.
All right,
my brother had
Mr.
given me
Officer.
a copy of.
Thank you. Hold on one moment, Attorney Bradel.
Thank you.
Thank you, Mr. Clerk. All right. Well, as you know, Counselor, sometimes persons who have restraining orders reach out to the persons who are prohibited from contacting them. Your client should be advised that notwithstanding whether or not this individual reaches out to him, he may not, under the terms of that restraining order, communicate with her. Is there anything else that you want to bring to my attention with respect to the bail the Commonwealth seeks and or the conditions of release?
Amen, San Antonio News. Amen. It is refreshing to see a prepared attorney come in ready to fight, knowing the facts, knowing the law, citing the facts, citing the law, staying on topic. It is very refreshing. No.
Please.
Judge, I just want to note that the new case was personal recognizance with a restraining order already in place. The old case was personal recognizance with no conditions whatsoever. I'm asking you to return Mr. Carney to the status quo. There's no problems. There's no issues. There's never been any problems with violating any court orders. And Mr. Carney just wants to make sure that he doesn't give, that the court, he hopes that and respectfully invites the court to not give these witnesses veto power over him being able to investigate the Reed case by just virtue of just showing up.
All right. Apio Mejia, do I have a carry?
I wonder what flustered Bradel there, because he was going along so nice, and then something flustered him. I don't know, but boy, he was not concentrating there at the end.
Yes.
Oh, thank you so much.
So we would ask you to return it to the status quo, Your Honor, in all respects.
All right. Thank you.
Thank you.
Mr. Novak, this defendant has no prior, real prior record, correct?
That's correct as far as I know.
And no real indication that he's ever failed to appear to answer charges against him.
I believe that's correct as well.
All right. After having heard argument.
Oh, Jesus. You know, this is the second time I've seen this judge. She is smoking hot for a judge. I mean, not looks-wise or anything like that, but man, she is just on it. I would love to practice law in front of her. I would love to practice law in front of her.
And understanding in particular that bail is necessary, cash bail is necessary only to ensure the defendant's appearance to answer the charges against him. I will not.
Oh, my understanding of Massachusetts law was correct. Nice.
Require a cash bail from Mr. Carney. He will be released on his personal recognizance with no additional conditions. Mr. Carney should be reminded, Mr. Bradel, that if, and he will be formally by Mr. Clerk, that if he is charged with any additional crimes, certainly there will be another revocation period.
Thank you.
Okay? The condition of release on personal recognizance is not committing any additional crimes. Mr. Clerk?
Much appreciated.
Actually, we have one more thing to address, which is, Mr. Bradel, you had filed this motion to strike, motion for remedial orders and sanctions. Is that now moot given my decision with respect to the motion that the Commonwealth had brought?
I don't believe it is, Judge.
Do you intend to press it?
I do intend to press it.
All right.
In fact, I wanted to provide the court, and I'll provide the court on Monday with some of the physical evidence of the result of the behavior.
All right.
So,
well, Mr. Novak, I know that I had ordered a deadline to respond. Does the Commonwealth need more time?
They do, Your Honor, because I'm not even aware of that.
All right. So here's what I'm going to do.
Any more time.
Yeah, I understand that Mr. Mello may be ill. What I'm going to do is set a deadline of a response to this motion to strike of March 8th. But if you need more time, if the Commonwealth needs more time, just let me know. All right?
He's in the hospital now, so I'm not sure, Your Honor.
I absolutely understand. I'm just giving a date so that we have one. But if you need more time, we'll get to it. Okay? All right. And you already have a next date in this case?
We actually have the 26th, Monday, but
No,
is that off or?
That's off. The next day we have is 4/23.
4/23, okay.
Is that okay?
That's fine.
That's what we had before.
And if
For
I
a free
have
trial?
any earlier motions, Judge, I'll mark them up.
When we get the opposition from the Commonwealth to your motion, we can schedule a hearing.
Thank you so much, Your Honor.
All right. Anything else, counselors?
No, Your Honor.
No, Your Honor.
All right, Mr. Clerk.
Mr. Kearney, you're being released on your own personal recognizance. Please be advised that while on personal, if you're arrested for a new crime, you can be held without bail for up to 90 days, and your failure to appear at a court appearance will result in a fine of
Fucking idiot. All right. Well, that is that. All right. So that kind of was about the way I expected it to go, having heard I only heard the prosecutor, so it went pretty much how I expected it to go, having heard the prosecutor. So I guess next we'll do this is DeCastro versus Peter et al. So Chille sent this to me, and this is a motion that is not yet been filed to get sanctions against Chille. There is a CCP 128.7. It's for filing a frivolous motion, and the way the statute works is that if someone files a frivolous pleading, before you file a motion for sanctions for a frivolous pleading, you prepare and serve the motion on the person who did the frivolous pleading. And you tell them, hey, if you don't withdraw your frivolous pleading within 21 days, I'm going to file this motion with the court, and I'm going to seek sanctions against you. So I got this from Chille. When did I get it from? The 21st? Let's see. The message from Katrinak was February 20th. So in roughly 21 days from the 20th, so 21 days from the 20th, you may see this particular motion filed. Now, I have not read through it entirely. I've read to the first section of it where he talks about a procedural issue. I skipped a lot of this stuff until this part right here. And this part right here leads me to believe that that Mr. Katrinak doesn't have good grounds. Because if that's what you're leading with, then that's bad. Why is he sending it to you so you cover it on your channel? Why is he sending it to me? I don't know why. The only message from him, well, I'll just share it with you. That was the only message from him. So, I don't know. All it was happy late birthday. Happy late birthday. I think so. He has shared previous things with me about blue bacon. My best guess would be that he knows that I have a significant amount of distaste for Puritini. And because of that, and I believe that he watches my coverage of him. He never takes my advice, particularly when I tell him how bad he's fucking up. But I believe he does watch what I do cover on his stuff, and he probably knows that I was shitting on Blue Bacon's attorney's attempted defense of his affirmative defenses that he pled twice without facts to support them, and the absurdity of trying to say that he didn't have to plead facts for those affirmative defenses when a judge had already found that he had to plead facts and already essentially ordered him to plead facts. And by that, I mean the judge granted the demur to those and the motion to strike to those. And so then Piratini's attorney, Blue Bacon's attorney, just goes back and refiles almost all of the exact same affirmative defenses, again, without pleading any facts. So he knows that he's so he I believe, and this is just my take it for what it is. I don't know the man's mind. I don't communicate with him. I have never responded to any of his emails. But my gut instinct is that he likes to hear me shit on his opponents. That's my guess. He likes to hear me shit on his opponents. And he wants to hear me shit on Piratini's attorney on this one. And guess what I'm going to do? I'm going to shit on him, most likely. Introduction. Ever so slightly. We're going to do that. We're going to do that. There. We're going to do that to there. All right. Plaintiff has made it clear he has two strategies in this case: to lay as much as possible and make defendant Piratini incur unnecessary and excess attorney's fees. This fact has been made abundantly clear by plaintiff's filing of his frivolous and meandering demur, which was filled with false statements and unrelated grievances concerning the discovery process. By this motion, Mr. Piratini seeks monetary sanctions against plaintiff for improperly and in bad faith filing his demur to Mr. Piratini's amended answer in this action. See, however much chaff Chille threw in, as long as Chille said, you didn't plead facts, you have to plead facts, and the court has previously ordered you to plead facts, or the court has previously made it clear that these particular causes of action need facts pled to them. As long as it's something even remotely along those lines, it was not a frivolous pleading. Plaintiff has already admitted that his demur was untimely without providing a valid reason for the untimeliness in the demur. I did point that out in my last video where I covered it. But he did it in the first demur that the court sustained. He filed it late. And he used the exact same excuse as he did this time, that he was attempting to meet and confer and whatever. Now, the court is going to give a lot of leeway to, apparently, because the court did it before, the court's going to give a lot of leeway to Chille showing that he's actually making good faith attempts to meet and confer, etc., right? And a technical issue the court can overlook, apparently, because it's done it before, because he was making a good faith attempt to meet and confer. He says, additionally, plaintiff has failed to meet his obligation to meet and confer with counsel for Mr. Piratini in good faith prior to filing his demur. Well, I read those, and they had a disagreement. They had a disagreement about what the state of the law is. Piratini's attorney pulled out of his ass a case where it was a bad faith case for an insurance company. Insurance companies have to represent their clients in bad faith, or they can't have bad faith when they deal with their insurance. So an insurance company has to deal with their insurance in good faith, and you can't deny a claim in bad faith. You can't improperly withhold payment. You have to make timely payment, etc. You have to provide attorneys for the defense, etc. And one of the things inherent in that is, well, if you rely on the advice of counsel, that's an affirmative defense, yes, but it's also part of what you have to prove to show that they were acting in bad faith. If they got advice from a counsel that says, "Oh no, this situation we're not obligated to do anything," and they act on the advice of counsel in good faith, well, you can't say there's bad faith there because they're acting on the advice of counsel. And so it is an affirmative defense, but it's also one that they don't have to like specifically plead facts to, because it's inherent in the cause of action, right? If they were relying on counsel's advice, then it is not in bad faith, just by definition, right? And so from that case, California has extrapolated out that if it's basically inherent in the cause of action, you don't have to plead it specifically. So, for example, I don't know, if someone sues you for negligence, and you don't have to like plead facts specific to say that you didn't act negligently. If you're I can't really think of one off the top of my head. It's late. I'm tired and I have heartburn. But whatever. What are you going to do? The point is that Piratini's attorney had a point. The problem is that a judge, specifically the judge that's going to be look at Chille's second demur, that same judge is going to look at Chille's second demur, has already made a ruling on Chille's first demur, where the facts haven't really changed. And the judge already said, yes, you need to provide facts, because he sustained Chille's demur the first time. So they had a disagreement. Piratini's attorney thinks he has some amazing new strategy, but Chille knows that he has a judge who's already granted a demur on exactly the same grounds. Additionally, plaintiff has failed to meet his obligation to be in confer on good faith. Okay, once again, counsel for Piratini emphasizes the fact that he has no idea of the basis of alleged liability for Mr. Piratini. Well, that's irrelevant. It's kind of funny that he accuses Chille of meandering, frivolous and meandering demur, and then he goes in his motion for sanctions on a frivolous demur, starts talking about how he, the attorney, has no idea of the basis of the alleged liability for Piratini. Oh, and then he goes into again, plaintiff's meandering complaint takes issue with the conduct of several people other than Mr. Piratini. We're just looking at your demur, sir. Don't accuse Chille of meandering and then meander yourself. It is the epitome of absurdity. It is the epitome of absurdity. The plaintiff is demanding more non-existent facts for affirmative defenses when plaintiff has refused to respond to discovery and provide any legal basis for any liability of Mr. Piratini. Well, here's the fun thing. The plaintiff is demanding that you allege facts. There's a difference between providing facts and alleging facts. So the reason why there is discovery, that defendants conduct discovery, is because the plaintiff alleges facts in his complaint. The plaintiff alleges facts in his complaint, and then the defendant does discovery to get the underlying facts that support the allegations to plaintiff's complaint. Likewise, the defendant has to allege facts in support of his affirmative defenses. Plaintiff is saying defendant hasn't alleged facts. That's separate and distinct from discovery. Just like plaintiff has to allege facts and then defendant can do discovery, defendant has to allege facts in support of his affirmative defenses, and then plaintiff can do discovery. Well, so I don't know why that matters. And I don't know why you would have respected Heller. He was a plaintiff. He didn't establish any of the law. He didn't argue any of his stuff. His attorneys did it. And the Supreme Court made a ruling. Now, if Heller paid to get that done, if it wasn't like a Rosa Parks situation, and Heller actually dropped a bunch of cash to fight it, then sure, that's respect worthy. But I mean, just because he was the plaintiff or respondent or appellant or whatever in a Supreme Court case doesn't mean he's some sort of a legal expert or whatever. Well, good for them. Maybe Chille can hire attorneys who can assist him in figuring out what is or isn't a worthy case to bring. Plaintiff's sole purpose in filing and maintaining his demurrer and this frivolous lawsuit is to harass and burden Mr. Piratini and needlessly increase the attorney's fees incurred in this litigation, or just going out on a limb here, or his sole purpose in filing and maintaining his demurrer is because you didn't plead any fucking facts in your affirmative defenses. I mean, maybe it has something with you not pleading facts. And why are you throwing, see, again, this is meandering. The lawsuit, the complaint itself has nothing to do with the demurrer. This conduct is sanctionable under CCP 128.7b. Plaintiff bringing this instant demurrer is not warranted by existing law. How the fuck can you say that when a judge has already sustained a demurrer and motion to strike that eliminated all but one of your affirmative defenses? You can't just replead them with no facts and expect them not to get demurred again. Right. I mean, they probably do. There's a lot of attorneys out there who will take the money. Take the money. There's a lot of attorneys who will just take the money. I know an attorney who would take the money, and he would spend the money doing the research to see if it's viable. And then after he spent the money, he'd say, hey, I did the research. It's not viable. So yeah, they probably do have bar card holders lined up. But again, I go back to my pro tip. If you want to be a plaintiff, if you can't find an attorney to take your case on contingency, it's probably not a good case. If you have to pay an attorney up front to be a plaintiff's attorney. It's probably not a good case. Either there is some issue with the facts, there is some issue with the law, or there is some issue with collecting the judgment. Maybe the facts are against you. Maybe the law is against you. Maybe the judgment is too small to make it worth an attorney's while, or maybe the judgment isn't collectible to make it worth the attorney's while. Finally, as a result of plaintiff's frivolous filing of this demur and the bad faith conduct by plaintiff, Mr. Piratini is forced to incur significant legal fees to attack the frivolous pleading. But you know what? How bad is it going to look? You know, let me actually check something. Because I'm just wondering, how bad is it going to look if in De Castro versus Peter, here's the minute order. Are you shitting me? This is the first time I actually looked at this. This fucking Blue Bacon's attorney set all of these motions for different dates. Instead of setting all the motions for one date, he set the motion to compel further responses for requests for admission on one date, then the one for production of documents for the next date, and he asked for this. Oh my god! Oh my god! Oh, that's not going to play well with the court. That's not going to play well with the court. But that wasn't what I was looking for. I thought it was a opposition shows extension. Straighten up, Paul. Keepernick. Oh, this is starting to burn so bad. You'd think I would learn and not eat pizza. Here we go. That's all the way out of June 4th. Oh my God. So 20 days from, let's say about 20 days from now, it'll be roughly what, the 17th? There's 21 days. So it'll be like the 13th or so, 13th or 14th is when Blue Bacon can file it. And this one was filed. So the Castro's was filed January 31st. And it was set all the way out in June. Why are they setting them out that long? Why are they sitting him out that long? I wonder if in Los Angeles County they can pick their own dates out into the future that far. Most of the courts that I work at, except for a few departments where you have like set dates where you can pick it to set it on, or where it shows you a calendar that you can pick. Mostly, the clerk will set the date, or you can ask to reserve one. I guess that's true. That's true. In one of the counties, you could ask to reserve it. Well, my thought process was that maybe the demurrer will get heard before the motion for sanctions can be heard. Because it would be kind of funny if this gets filed by Piratini's attorney and it goes and Chille wins his demur, which he should, and then this motion comes up and the court will be like, it's not really that frivolous considering that Chille's already won, bro. All right, so the court should award monetary sanctions, yada yada. The court should not. Furthest demur was filed late. Yep. Which is an excellent argument, except this is an excellent argument. Plaintiff did file late. He had 10 days. He could have got an extension, yada yada. And he didn't do it, except the court accepted the exact same argument last time. So I don't know how that's going to work. He failed to properly meet and confer. And then he admits that counsel for Mr. Piratini did have to cancel a scheduled meet and confer phone call due to an unforeseen emergency. So it's okay when Blue Bacon's attorney does it, right? These written meet and confer attempts laid out the legal basis for Blue Bacon's position regarding the amended answer and requested that a plaintiff explain in detail how he disagreed with the case law the counsel for Mr. Piratini had provided. Yeah, except for the fucking fact that the judge had already essentially ruled that those affirmative defenses need fucking facts. His frivolous demur and attempt to frame his repeated stonewalling as fulfillment of his meet for obligations. Like I literally just don't understand how this Paul Katrinak doesn't understand that the judge already granted a demur to those exact same affirmative defenses on the basis that they failed to state facts, to allege facts. I don't understand why he thinks that all of a sudden some brand new argument is going to change the judge's mind. And why didn't he make this amazing argument the first time they were up on the demur? Well, I hate to break this to you, Laura, but I haven't seen a politician yet that doesn't run for office as a grift for campaign donations. Have you seen a poor politician yet? It's amazing. The who's that gal? She's really kind of cute from New York. Empty bubblehead. What the fuck is her name? Cute gal. Used to be a bartender. Basically broke as a joke. Gets elected to the House of Representatives. Instant, basically multimillionaire, right? Instant, basically a multimillionaire. AOC, thank you, Laura. And you know the Republicans make a great deal of hay about this. The Republicans make a great deal of hay about it. Like, oh, she's obviously corrupt. Yeah, but show me a Republican that isn't a multimillionaire. Show me a Republican that doesn't make more money doing the exact same thing. Like, I'm sorry, I'm not going to get political on this, but they're all fucking corrupt. So Chille would fit in perfectly into that grifting bag of people. The problem is that Chille's not as good at as the existing politicians are. He's not a good politician. He'll never be a good politician. The actual politicians will eat his lunch. They will eat his lunch. Real politicians are way better at grifting and stealing and lying than Chille. Chille's problem is that he's too honest about some things. And a real good politician would never say some of the things that Chille said. You're in the House, you're in the Senate. What political position do you hold, Christine Lovelace? We've stopped the stream. We're just going to wait for you to respond, because I will send you a campaign donation. Oh, he's honest. He's just honest about the wrong shit, bro. He's honest about the wrong shit. Like when he started telling black people that they weren't black enough. What was that? What was that? He was talking to a black guy, and he started telling the black guy what it's like to be black in prison. Fucking hell. Yeah, she's cute. You're lying if you say you kick her out of bed. Don't get mesmerized by them big old socialist titties. Why not? There's a lot of them that have been elected into office in a lot of cities. A lot of DAs run on stuff like that. That is entirely it, Laura. He does not know how to censor himself. Like when he got mad at that airport rant that he did against Blue Bacon. That was him being honest. It's him being honest. Well, I mean, I never said that she was smart or anything like that. All right. Anyway, sorry. The court should deter these bad faith tactics. Yeah, sanctions are warranted. Anyway, it's a Dookie motion. It is a Dookie motion, and there we go. The other thing that I wanted to cover, since I am still irpy, is in Springer. Springer's attorney filed an amended complaint. Let's take a look at it. Let's take a look at it. 15 pages. I hope he is less verbose than he was the last time. I have not read it, so we will get to read it together. This is the second amended complaint. You know your attorney is an excellent attorney if you're on the second amended complaint and you're still seeking injunctive relief after 3, 4. Let's count the appeal. 5. At least 5 shots at getting injunctive relief. Wait, hold on. And then there's the request for injunctive relief pending appeal. So 6. 6 shots. 6 shots. Well, there goes my opinion of you, because, you know, the more the merrier, and, you know, hey. No, I'm not doing New Mexico versus Springer. I don't know what New Mexico versus Springer is. Does the state of New Mexico have a lawsuit against him or a criminal action? That'd be interesting to know. Comes now, plaintiff with his second amended complaint for declaratory relief only against the individually named defendants acting in their individual capacities under color of law, and for damages against the 7th Judicial District Court pursuant to the Mexico Civil Rights Act, and states as follows in support thereof. Introduction. Motherfucking Thomas goddamn Paine. Thomas Paine is an excellent politician and a great source of insight into politics and into the political beliefs of colonial America. And he was a brilliant man and all sorts of wonderful things, but he wasn't a judge. And there is a distinction between politics and the law. Now, sometimes that distinction gets blurred, but your political beliefs should not influence a legal outcome. Should not. And as much as I despise Donald Trump, because he's Donald Trump, shouldn't change the law. The law should apply to him the same as it applies to everybody else. And it should apply to everybody else the same as it applies to him. So over politics. Anyway, Thomas Paine in American Crisis stated that tyranny, like hell, is not easily conquered, yet we have this consolation with us, that the harder the conflict, the more glorious the triumph. Alexander Hamilton, who also was not a judge, said there is no liberty if the power of judging be not separated from the legislative and executive powers. What the fuck are we getting at here? Another an attorney that I know and respect taught me that judges like to read mystery novels, but they want to read them knowing who did it from the beginning. They want the last page first. They want to know Bob killed Susan in the kitchen with the candlestick. That's what they want to know. And then they want to know everything that led up to it. Oh, Lincoln was the worst president ever. How about that? Literally, bar none, hands down, the worst president ever. The only president ever to be so bad that basically half the nation said, you know what? I would rather fucking leave. That's how bad Lincoln was. Literally the worst president. But back to legal writing. Just starting to throw out quotes. Starting to throw out quotes without context. Why are you telling me about tyranny like hell is not easily conquered? Why are you telling me that the power of judging has to be separated from the legislative and executive powers? Why not just tell me that oh yeah, there's a division that we have the executive branch, we have the legislative branch, and we have the judicial branch. Like I don't understand. What are you telling me? So, and that's the problem. You start off by saying it's rule. No. CRAC and IRAC. Issue, rule, analysis, conclusion, or conclusion, rule, analysis, conclusion. It's CRAC. Conclusion. This is what I'm proving. This is what I'm showing. Then the rule, then the analysis, then the conclusion. This introduction is wasted so far. Robert Bork, who is a very controversial figure, if I remember my 1980s Supreme Court nominees well, he was he was an attorney general, right? And he was nominated for Supreme Court. Anyway, Robert Bork articulated well that a respect by the judiciary for the balance of powers as originally intended by the framers. A respect by the judiciary, the balance of powers as originally intended by the framers must appeal to a common sense of what judges' roles ought to be in a properly functioning constitutional democracy. We're a motherfucking republic. We are a motherfucking constitutional republic, not a constitutional democracy. So Robert Bork fucked up right there. Yeah. See, I remember shit sometimes. I don't know that it's a thing in legal circles, but getting porked is a thing that wouldn't be amiss from time to time. What the fuck are we talking about here? Robert Bork articulated well that a respect by the judiciary for the balance of powers as originally intended by the framers must appeal to common sense, but a judge will be in a properly functioning constitutional democracy. I don't understand what the fuck that sentence means. I don't understand what the fuck that sentence means. I honestly, I'm not even fucking with you. I don't understand what that sentence means. Robert Bork articulated well that a respect by the judiciary for the balance of powers as originally intended by the framers must appeal to a common sense of what judges' roles ought to be in a properly functioning constitutional democracy. I don't know what the fuck that sentence. That doesn't mean anything. That is word salad. I mean, what Robert Bork said that didn't include all of this bullshit might have made sense when he started off with something and then continued with appeal to a common sense. I mean, that might have made sense. But this Frankenstein of a sentence is meaningless. Judges are not to overturn the will of legislative majorities absent a violation of a constitutional right as those rights were understood by the framers. Who the fuck in Springer versus the 7th Judicial District Court, where were judges overturning the will of legislative majorities? Where did this fucking happen? What the fuck? I don't understand. I don't understand what's going on. John E. Thompson, what's the big deal? The unconstitutionality of God in the Pledge of Allegiance? Citing Robert Bork attempting to give America the usurpation of law by politics? Is that's what he's saying? But where are the judges in Springer versus the 7th Judicial District Court? Where are they going against the governor or the New Mexico legislature? Where? I mean, that's great, but what, I mean, everybody else is saying like it's so clear, but like what? Oh, Jesus fucking Christ! Oh, maybe I'm dumb. Maybe I'm not. Maybe I don't. Maybe I'm just dumb, and I'm missing the big picture about how the judges in the 7th Judicial District Court are overturning legislature laws from the legislature and orders from the governor. Maybe I'm just missing that. Maybe I'm just missing that. Because my understanding of Springer versus the 7th Judicial District Court is that Springer went to the court and allegedly interfered with the operations of the court by recording, by violating mask rules. And he was essentially told that he could only go there on official business and he had to have a sheriff's deputy escort him. That's the only way he could be in the courthouse. He did not like that, and he sued. What in that is a judge usurping the role of the legislature or the executive branch? Where does that happen in those facts? Well, I mean, unless I'm wrong, and I may or may not be wrong, but this Blaine, whatever, what the hell is his name? What the fuck is his name? A. Blair Dunn. He's got some family law cases that he's done appeals on, and if I am not mistaken, he has cited like Thomas Paine and shit in some of those appeals. I mean, this dude loves his politics. No, he has a penchant for this. He loves this language, Mr. Lucas. He does love this language. All right. So, all right. No, a new quote. This is in all of us a strong disposition to believe that anything lawful is also legitimate. This belief is so widespread that many persons have erroneously held that things are, quote, just, end quote, because law makes them so. Quoting Frederic Bastiat, The Law, the Foundation for Economic Education Incorporated, Irvington on Hudson, New York, 10533. Here, the 7th Judicial District's employees appear to have fallen prey to the fallacy that just because the operate with the authority of the judiciary, that they themselves are above the law and must pay no heed to the rights of the citizens and of the press. Okay. Okay. General allegations. plaintiff is an independent investigative journalist who produces content intended to expose to the general public cases of government fraud, waste, and abuse. In the first quarter of 2023, plaintiff engaged in investigative journalism at the Moriarty Magistrate Courthouse, specifically in the domestic violence docket that was being heard by essentially a magistrate. Investigative journalism in a DV case, in a family law DV case, not a criminal DV case. While most of plaintiffs' investigative journalism focuses on police misconduct and abuse of power, plaintiff also exercises his First Amendment rights to produce content related to other government officials besides police officers, including but not limited to local elected officials and government employees and judicial officers and administrators. Plaintiff displays the content described in paragraphs 8 through 10 above on a YouTube channel he operates called James Freeman. I thought it was different. It's like something news network, fake news network, or something like that. Anywho, approximately 444,000 people around the world subscribe to and enjoy plaintiff's YouTube channel called James Freeman. The content plaintiff posts in his YouTube channel and on other social media platforms often receives tens of thousands of views and frequently sparks robust debate about matters of public interest related to constitutional rights, the workings of government, and other related matters. In February 2023, plaintiff posted one or more videos featuring interactions with a domestic relations hearing officer. I told you, I knew it was fucking the DV. He was in there on family law DV. He's like, I'm gonna fuck with a family law DV officer because it's just so terrible for the courts to get involved in domestic violence because, I don't know, either husbands should be able to beat their wives, wives should be able to beat their husbands, or maybe we should just do the Chille method and stick them both in a fucking bus with cameras and make them talk it out. Or beat each other to death. One of the two, doesn't really matter. But why do we need to have rational people who aren't involved in the conflict get in there and maybe, adjudicate the matter for them? The DV Rumble Bus coming soon to a neighborhood near you. Make sure you gotta have a lot of cameras because you want to broadcast this coast to coast, 24/7. Hop into the DV van, the DV bus. Fucking. Jesus, Chille has the best fucking ideas. J5, great point. In February of 2023, plaintiff posted one or more videos featuring interactions with a domestic relations hearing officer in the 7th Judicial District Court for Torrance County, as well as with other court personnel and employees of the Torrance County Sheriff's Office. On or about March 1st, 2023, two officers with the New Mexico State Police hand-delivered to plaintiff an administrative order entered on March 28, 2023, and signed by the Honorable Mercedes Murphy, Chief Judge of the 7th Judicial District. See exhibit attached here to incorporated herein by reference as Exhibit 1. Wow, boy, they really skipped over what happened. They really skipped over what happened with the interaction with the domestic relations hearing officer. They really skipped over that part. Nothing happened. He's just reporting. He was just minding his own business. Just with his little pen and pad of paper, just taking notes in the DV here. Johnny reporter, Johnny on the spot, Nothing doing, he's just taking notes, minding his own business. He's a good boy. He didn't do nothing. Well, sir, apparently you have never seen Jerry Springer. People seem to love that shit. Yeah, maybe I'm jaded because I've had to sit through so many family law hearings. Because as a first-year family law attorney, you just sit through family law hearings all day long, all day, every day. And while you're waiting for your case to get called, you're listening to everybody else's bullshit case. And yeah, I don't know. I guess you get a little numb to the drama of it. You're just like, dude, just can we state the facts and move on with it? But other people, if you only get it for like a half-hour day, maybe an hour a day, other people seem to eat it up. That shit's popular. Shit's popular. Pursuant to the administrative order attached here to is Exhibit 1, plaintiff is banned from entering the Torrance County District Court at the Neil Mertz Judicial Complex, 903 North 5th Street, Estancia, New Mexico, 87016, unless appearing for a hearing or having specific court business. In the event the plaintiff is to appear at the location described above in paragraph 13, in the event the plaintiff is to appear at the location described above in paragraph 13, well, you mean on his YouTube channel? Retarded. Maybe he's talking about the Neil Mertz Judicial Complex in paragraph 16. The administrative order attached here to is Exhibit 1 requires a plaintiff is escorted by, not just escorted by, but escorted by and accompanied by. Not just accompanied by, escorted by and accompanied by. The Torrance County Sheriff's Office while in the building. The whole office or just a deputy? I don't know. You tell me. The administrative order attached here to is Exhibit 1 further orders the judges and decrees that upon entering the Neil Mertz Judicial Complex, plaintiff shall enter the Torrance County Sheriff's Office and identify himself as being an obstinate visitor and alert law enforcement the plaintiff must be escorted and accompanied pursuant to the administrative order. On or about March 1, 2023, at the same time, officers of the New Mexico State Police hand-delivered to plaintiff the administrative order attached here to is Exhibit 1. Those same officers also hand-delivered to plaintiff a letter from Jason Jones, Court Executive Officer of the 7th Judicial District Court. See exhibit attached hereto and incorporated herein by reference as Exhibit 2. You would think that, good night, Skywalker, you would think that a attorney would be aware that the clerk will often send out notices of things. And it's essentially just like service. The clerk provides service for the court. So the judge will issue an order, and that order has to be served on the person who has the order against them. Now, normally, like if the person is present when the order is issued, the judge can just hand the order to the bailiff. The bailiff will walk right over and hand it to the person. Easy peasy lemon squeezy. However, sometimes judges make orders like if they'll take it on submission, like the parties finish their arguments in front of the judge, and the judge says, "Okay, I'll take it under submission, and I'll issue my ruling in the next few days." Well, when the judge prepares and issues his or her ruling, the judge can't just have the bailiff hand it to the parties. So the judge will have the clerk serve it on the parties. That doesn't mean the clerk is somehow culpable for or liable for the order of the court. The clerk is serving it. And in this case, I believe that Jason Jones was serving the order of the court, because Jason Jones wasn't issuing any trespass orders or anything like that. He was just relaying the order of the court. The letter attached here to as Exhibit 2 describes the contents of the administrative order attached here to as Exhibit 1. Well, usually when you serve a document, the proof of service or what the clerk would send out would describe what the document is that's being served, oddly enough, but provides no notice of wrongdoing plaintiff is alleged to have committed that he could legally be deprived of his rights under the New Mexico Bill of Rights. Well, that's because there's already a court order. The clerk isn't making any decisions about what the court order is or should be. The clerk is just saying, this is a court order. I'm serving it on you as the clerk. You would think, one would assume, an attorney of A. Blair Dunn's caliber, as according to James Springer, is the best attorney in New Mexico. One would assume that the best attorney in New Mexico would know the function of the fucking clerk. That would be awesome. On March 23rd, 2023, the chief judge of the 7th Judicial District Court entered an amended administrative order, amending the administrative order attached here to as Exhibit 3 to include a ban on plaintiff entering various other properties of the 7th Judicial District. See exhibit attached here to and incorporated herein by reference as Exhibit 3. On March 23rd, 2023, Jason Jones, 7th Judicial District Court Executive Officer, signed a letter addressed to plaintiff in which Mr. Jones explained the contents of the amended administrative order attached here to as Exhibit 3. See attached exhibit here to and incorporated herein by reference as Exhibit 4. In the letter attached here to as Exhibit 4, Jason Jones alleges that plaintiff entered the Moriarty Magistrate Court for non-court business and was being, quote, disruptive and threatening, in quote, in the courthouse. Plaintiff was never given notice and an opportunity to be heard on the matter of the deprivation of his rights under the First Amendment, 14th Amendment, or Article 2 of the New Mexico Constitution that resulted from the actions of the defendants as described in paragraphs 15 through 23 herein. Now, boy, talk about an aptly named person. Damn, son. Like, you picked the perfect name for yourself. I am impressed. So you could trespass someone, and then they would have an opportunity, as long as they have like an opportunity for a hearing, you can have the deprivation of rights, and then as long as you have the hearing afterwards, right? And it does bother me that Freeman wasn't, at least allegedly, wasn't given notice and an opportunity to be heard before the court issued these orders. That does bother me. It bothers me a lot. And I really wish his attorney would address that because that seems like a violation of procedural due process. Now, I know that A. Blair Dunn has alleged a violation of substantive due process in his last one. I don't know if he's alleged procedural or substantive in this one. I haven't read this, but this is 15 pages, bro. It says it near the top of the screen, 6 out of 15. But I said way at the very beginning of this that there might be a procedural due process violation there. So That'd be interesting to see. On May 18th, 2023, plaintiff attempted to exercise his rights as guaranteed under the United States Constitution and the New Mexico Constitution by attending a public hearing as a member of the press to report on the matter on the case in a criminal matter before the Honorable Mercedes Murphy by way of a video conferencing platform. After dialing into the public hearing via the video conferencing platform, Judge Murphy summarily objected the plaintiff from the video conferencing platform and from the public hearing without providing plaintiff notice and an opportunity to be heard on the matter of whether he could attend the public hearing. I'm wondering what we're missing there. Because I dialed into the Zoom hearing on Turtle Boy today, and it was open to the public. It was cool. Everybody could just go in there, and as long as I guess you don't cause any problems or whatever, you could watch. So one of two things really is banging around in the cabeza. Either number one, it wasn't an open video conferencing platform. He's characterizing it as a video conferencing platform, but it might have been a Zoom conference hearing for participants only. Like if he's trying to get in on one of the DV cases, it might have been a hearing that only the parties and the counsel for the parties were allowed to attend. That's situation number one. Situation number two would be where he made an ass out of himself or something, because somehow it came to somebody's attention. I don't know if it was Judge Murphy or a clerk, or I don't know who did it, but somebody, if it's true that he was ejected, somebody ejected him. So either he wasn't a party and it was party only, or he made an ass out of himself, right? And I'm not sure that you need a notice and opportunity to be heard to be ejected from a public meeting. I'm not sure that would be something that you would need notice and an opportunity to be heard. Like if you're causing a disruption at a public meeting, I am under the impression that you can be trespassed, ejected, whatever. Oh, honey, you got to buy me dinner first. On May 24th, 2023, Judge Shannon Murdoch Poff issued an order, Exhibit 5, attached here, to exclude plaintiff from a hearing in a civil matter. Is that a civil matter? That looks like a DV. That looks like a DV. Oh, hell yeah. Oof, oatmeal cookies. Call me what you will, but I actually like oatmeal cookies with raisins. I know that's heresy. I like oatmeal cookies with raisins. That probably makes me a bad person. I'm sorry, DV is domestic violence. So when you see a DV in there, that screams domestic violence. That's not unwarranted. I know. The raisins in oatmeal cookies is a very touchy subject. So yeah. And I'm not entirely sure that DV matters are open to be filmed by the press. I mean, maybe the press, but there's hundreds of domestic violence cases a day. Like where like what makes this particular DV case pressworthy? On multiple dates, we're not going to allege specific dates because fuck that. Why would we? Susan Rossignol has either refused plaintiff's statutory right under New Mexico law to petition his government for redress of grievance by inspecting records in the clerk's office. Am I missing something? On multiple dates, Susan Rossignol has either refused plaintiff's statutory right under New Mexico's law to petition his government for redress of grievance by inspecting records in the clerk's office. I don't fucking know. I'm moving on. That doesn't make sense. You can't inspecting records, refusing to allow someone to inspect records does not violate the First Amendment right to petition the government for redress of grievances. You have the right to petition your government for the redress of grievances. I don't know. Defendant Rossignol, out of retaliation, has required state police presence to harass and intimidate plaintiff when he entered the Estancia District Courthouse for the purpose of conducting court business associated to making records requests. Date? Was that before or after the court issued an order requiring him to be escorted? I don't know why, but I like you, sir and or madam. This retaliation culminated in an outright refusal to accept protected petitioning activity to exercise his statutory right to request public records on June 8, 2023, and Ms. Rossignol requiring the Torrance County Sheriff's Deputy Young chase plaintiff from the building, which he did. This retaliating for what? What is Rossignol retaliating for? Culminated in an outright refusal to accept protected petitioning activity. What is that? What petitioning activity? To exercise his statutory right to request public records. Yea, and verily, I saith unto thee, go fuckest thyselfest. I don't know what that means. On October 31st and November 1st, 2023, plaintiff entered the public areas of Torrance County Courthouse on October 31st and November 1st, 2023, plaintiff entered the public areas of the Torrance County Courthouse facility in full compliance with the 7th Judicial District Court's administrative orders at issue in this matter and made several videos as part of his reporting and as expressive conduct. Excuse me if I am wrong, but how could he have been in full compliance with the 7th Judicial District Court's administrative orders if he was there making videos instead of being there on official court business? So, paragraph 16, pursuant to the administrative order, plaintiff is banned from entering the Torrance County District Court unless appearing for a hearing, I'm assuming his hearing, or having specific court business. So how could he be in full compliance if he was there to make several videos as part of his reporting and expressive conduct? Okay. Well, I mean, it's a request. It's not really petitioning. Like, my understanding of petitioning the government, like, in case law that I have experienced, that I have seen, that I've read, petitioning and assembly are the two things that are tied together, as far as like whenever there is a case on petitioning, on petitioning, it's normally tied to freedom of assembly because it involves picketing, protesting, that kind of stuff is actively petitioning the government. It's the poor man's version of petitioning the government. The rich man's version of petitioning the government is obviously buying politicians. The middle ground is where you go to court and you file what's literally called a motherfucking petition or complaint or what have you. A request, is that really a petition for redress of grievances? Because you have to remember, the First Amendment doesn't say that you have the right to petition the government. It says you have the right to petition the government for redress of grievance. Let's First Amendment to the Constitution. Constitution. It just, this isn't the actual text of it. I'm looking at the text. The text. Here we go. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now, maybe I'm wrong. Maybe it's Maybelline. But I don't think that a request, a FOIA request, is petitioning the government. Theoretically, it could be, but I don't know. I don't think so. It would be a novel use of it. So anyway, he was filming in retaliation for plaintiff's reporting and protected speech contained in the first video noted in the paragraph above. Well, so he's in the public areas. He's in the public areas of a courthouse, but what kind of a forum is a courthouse? I would argue that it's most likely either a non-public forum or a limited public forum. Either way, the test is going to be the same. If the government tries to restrict your First Amendment rights in that forum, it's going to have to be viewpoint neutral. It has to there has to be a legitimate government purpose, and it has to be rationally related to the legitimate government purpose. I agree, Bill. So is there a legitimate government purpose in not allowing specifically James Springer to film in the courthouse? Well, maybe. I mean, I don't know. I really have to look at the facts on that. Was he causing a disturbance? Was there an issue? Well, apparently there was an issue because he created enough of an issue that he got the judges to say, you can't be here anymore unless you're on official government business. But after they issued that order, then he shows up and he starts filming when he doesn't have official government business, which makes me think that he, in fact, was a problem. It just makes me think he was a problem. So was there a legitimate government interest? Well, that's going to be a question of fact. Is the rule prohibiting him from being there. Well, so it's not even. It's like getting trespassed from someplace, because essentially he's been trespassed. Essentially, he has been trespassed from the court. But then going to the place you've been trespassed from and engaging in a protected First Amendment activity, and then pretending that somehow, simply because you're engaged in a protected First Amendment activity, that you can just ignore the trespass. It's the same thing that auditors do when they go and they like when Chille interferes in a traffic stop while he's holding a camera, and he believes that just because he's recording it, just because he's engaged in a First Amendment protected activity, that he can then commit crimes with impunity because he is engaged in a First Amendment protected activity. And when the cop deals with him and arrests him or cites him or whatever, the cop isn't doing it because of the recording. The cop is doing it because, he's interfering with the stop. In this particular case, when he entered the public areas and the defendants did whatever, I guess in this particular case, maybe I got ahead of myself. So in retaliation, the defendants or employees of the defendants acting at their direction conspired to have YouTube censor plaintiff's video, resulting in the following. And again, this is incredibly weak sauce. Like, you have to show that they have some sort of a coercive control over YouTube. And it's going to fail for the same reasons it failed the previous time that they tried to make this argument. So he had his one URL. They found where the URL was. They removed the content. They removed a URL. They removed a URL. Read it. Read this motherfucker. They removed a URL. They didn't remove a video. They removed a URL. Well, so Laura, you are assuming that someone filed a complaint. I remember I've looked up this particular URL, and it's like a Google page. Hold on. https://g.co/kgs/9s85D capital M. Enter. That's what the URL brings up. So who would make a report on that, Laura? Well, they didn't report a video. A URL was removed. I don't believe so. I believe that it probably got caught in the. I think it probably got caught by an algorithm. Yes, he did. I fucking love the vacuum bit. His URL getting removed. All right. Close. close. I'm closing these so I don't accidentally click on them. All right. So we just got through that, and now we're going to go to this type of government action is violative of the rights protected by the United States and New Mexico constitutions. It is precisely the type of conduct that the Fifth Circuit has affirmed to warrant preliminary injunctive relief in Missouri v. Biden. Yeah, so again, the Missouri v. Biden thing was where the government actually specifically worked with, I think it was Twitter, to remove accounts, to hide accounts, and they directed Twitter to do it. And the actual parts of the executive branch were directing and if you don't do it, we're going to do X, right? Whereas what the fuck is the 7th Judicial District Court going to do to Google? The answer to that is nothing. They're not. And plaintiff has also been able to successfully appeal the action to censor speech and press, but upon information relief, understand that the defendants will continue to undertake these actions, to censor plaintiff's reporting and speech unless enjoined by the court. But again, remember what was censored was a URL that pulled up a Google search for Torrance County Superior or Torrance County District Court. I don't know what the fuck, dude. So if shit, I didn't mean to do that. So if the defendants had the kind of coercive control that is talked about in Missouri v. Biden, then plaintiff would not have been able to successfully appeal the actions. They're mutually exclusive. The fact that plaintiff was able to successfully appeal the actions to censor his speech in huge air quotes means that YouTube is not under the control of the defendants. Further, defendant Rosendahl, upon information and belief, at the direction of defendant Murphy, falsely reported to the New Mexico State Police that plaintiff was an armed threat and proceeded to close her government office to the public during normal business hours in an effort to place plaintiff's life in jeopardy and deprive him of his statutory and constitutional rights to petition his government for redress of what? So she closed her office during normal business hours, and that is a deprivation of plaintiff's constitutional right to petition his government for redress of grievance. Wouldn't you have to allege, I don't know, that he was attempting to file a petition, file a complaint, file an appeal, file something? Wouldn't you have to show that? Just alleging that she closed her office during normal business hours, that doesn't show that she actually deprived him of anything. You have to say plaintiff went to the court on X date at Y time to conduct the normal business of the court by filing a complaint against X, Y, and Z. So it'd be Springer versus Bob Smith. Rosendahl, upon seeing plaintiff to violate his right to petition the government for redress of grievance, closed her office during normal business hour and refused to accept his petition, his complaint, whatever. That's what you'd have to do. That's what you'd have to show. That's what you have to at least allege, I should say. Have anything resembling a coherent and valid complaint. Count 1, violation of freedom of speech in the press. Viewpoint discrimination. It's a mighty tall order there. Plaintiff incorporates preceding paragraphs. The First Amendment of the United States Constitution protects freedom of expression, speech, and the individual's right to petition the government for redress of grievances. Again, like it doesn't stop at redress. It's for redress of grievances. Moreover, the First Amendment prohibits infringements on the freedom of the press to report on the affairs of government by the government. To report on the affairs of government by the government. As government actors, individually acting under the color of law, Judge Murphy and Judge Murdoch Hoff engaged in viewpoint discrimination by banning and excluding plaintiff from public places and hearings. Public places and hearings. Have a good night, Josh. Well, go hang out with Josh. He'll get you all buzzed up again. Prohibiting him attending and reporting on public matters. There is already a case on this. God, what was the name of the case? Was it Brandsburg? Was it Brandsburg? Branz Berg v. Hayes. Brandsburg v. Hayes? No. What was it? There was a case. It was a Supreme Court case. It's not coming up. God, what was it? Richmond newspapers versus Virginia. This wasn't it. There was a Supreme Court case where essentially the Supreme Court said that the press don't have any greater or lesser rights to attend trials than the public do. So and there are certain circumstances where the public can be excluded, and problem people can be excluded, etc. Oh, what's going on? There's something going on. Let me look. Well, just because he's not gay doesn't mean you have to like. I mean, yeah, yeah. Anyway, I don't remember there is court cases on it. You can exclude. Hold on, Estes versus Texas. Supreme Court, you can exclude the press from recording in courtrooms. That's not really what I'm looking for, though. Anyway, as government actors individually and acting under color of law, Judge Murphy and Murdoch-Poff engaged in viewpoint discrimination by banning and excluding plaintiff from a public places and hearings, prohibiting him attending and reporting on public matters. Well, yeah. The question would be, I still think the question would be whether or not he had the procedural due process, the right to notice, or the notice. He got the notice, he got served with it, but the hearing, that's the question that I have, the procedural due process. Judge Murphy and Judge Murdoch-Poff do not enjoy judicial immunity here for their administrative orders. Judge is not immune from liability for non-judicial actions, i.e., actions not taken in the judge's judicial capacity. I'm going to guess an administrative order like this would be taken in the judge's judicial capacity. I think that I don't know how the federal court is going to handle it, because my understanding, and my understanding may be wrong, is that there is something ongoing on this. My understanding is that there was a criminal contempt that the court asked the district attorney to bring against Freeman, against James Springer, that the district attorney declined. But that doesn't mean that there isn't because something was transferred, if I remember correctly, something was transferred to a different district for hearing. So that leads me to believe there is still ongoing litigation on this. And I don't know if the federal court is going to want to back out until the state court has the opportunity to actually come to an adjudication. Actually, like, okay, so you can do the deprivation of rights as long as there's going to be like a follow-up opportunity to be heard. There's going to be a follow-up hearing, and if the state is giving him that follow-up hearing right now, it should be adjudicated in the state before a 1983 action. But I don't really see a First Amendment deprivation that would be actionable, because the forum analysis again would come into play. But I mean, if they said no filming, if they said no reporting in the courthouse, if they said that, and I'm not saying they said that, but if they said that, then there'd have to be a legitimate government purpose. It'd have to be rationally related to achieving it. It'd have to be viewpoint neutral. It doesn't have to be content neutral. But in this case, he's still basically he's been trespassed, and he wants to go in there and record and things like that. But it's like if you've been trespassed from a place, you still have freedom of speech. You just can't be there. You can't be there. This important legal principle was recently applied to bail in the context of suing members of the judiciary in Schultz versus State. an Alabama case. He's cited a Fifth Circuit case. Now he's citing a Northern District of Alabama case. I'm just going to go out on a limb here and suggest to you that the Northern District of Alabama is not in the same circuit as New Mexico, where the district court applied the guidance from the 11th Circuit, which is also not New Mexico. They can't? Have you explained that to the Supreme Court, that the Supreme Court can't pick and choose what media has access? Last I checked, the Supreme Court issued press badges, press passes. They picked who got to have access. So can you explain to me how the Supreme Court is violating this particular rule that you're citing? The judges can't pick and choose what media has access? And why can't they trespass someone? Well, first of all, they didn't trespass him. It's, like I said, akin to trespass. It's similar to, he's still allowed to be there. He's only allowed to be there, though, for the official business of the court, which really strikes me of Adderley versus Florida, where the Supreme Court said the state, no less than the private owner of a business, can preserve the property for its lawfully intended purpose. Passes aren't issued based on the typical content by the particular media outfit. Well, hold on a second. That's different, Mr. Lucas. You said the judges can't pick and choose what media has access. And then you're saying that what they aren't based on the typical content by the particular media outfit. But they're still picking and choosing. They're just not picking it based on these particular things, according to you, allegedly. They can't say only conservative media, but they can still pick and choose what media has access. They actively do pick and choose what media has access, Mr. Lucas. And courts can and routinely do on big trials, on major trials, pick and choose which station has the camera, if there's going to be a camera in there. They're going to say this station gets to have the camera in. What factors, Mr. Lucas? They are picking and choosing. They are picking and choosing. Issuing passes based on factors not related to content. They're still picking and choosing, sir. And don't think for one fucking minute if someone like James Springer walked into the Supreme Court, if he did manage to get a pass to get in there, and if he acted a fool like he did in the 7th Judicial District Court, don't think for a fucking minute that he would never be back in that Supreme Court. Okay, that doesn't negate what I said. The judge would still pick which station got to do the camera. Anyway, you're wasting my time and everybody else's. Thank you, sir, and good day. So again, we're talking about the 11th Circuit. What circuit is the New Mexico? I thought it was the 10th Circuit, but let me just see. What circuit? 10th. It is the 10th. Aha! Good again. Damn, I'm good. So now they're looking at the 11th Circuit. They're still in the 10th Circuit. I don't know why. But the district court in a completely different circuit, Alabama, would be what? Would Alabama be 11th Circuit or 5th Circuit? I don't remember. That a court looked at the nature and function of the act, not the propriety of the act itself, and considers whether the nature and function of the particular act is judicial. Yeah, issuing an administrative order that bans someone from, that would be, I think that would be a judicial act. Under McCullough, court should consider the nature and functions of the alleged act are judicial by considering the four factors. Nice. The precise act complained of is a normal judicial function. Yes. Issuing something that is essentially a restraining order or a trespass order or something like that would be a normal judicial function. 2, the events involved occurred in the judge's chambers. Well, orders are normally signed in the judge's chambers. So yeah, sure. 3, the controversy centered around a case then pending before the judge. Well, if you look it up, there was a case number. There were actually multiple case numbers for these. So I'm going to say that yes, it did involve a case then pending before the judge. And 4, the confrontation arose directly and immediately out of a visit to the judge in his official capacity. It was out of a visit to the judge in his official capacity. I don't know how that would apply, because I believe they were stylized in re the matter of James Springer. So they're none of the conduct complained of fits within the Morales, whatever definition of judicial conduct warranting absolute judicial immunity. I don't know why we're talking about this. They're not looking for money. I don't know why we're talking about this. As a direct and proximate result of the retaliatory actions, plaintiff suffered injuries consisting of deprivation of a constitutional right. Plaintiff seeks declaratory relief and injunctive relief to halt the continuation of these deprivations. Well, I don't know if the federal court is going to want to make a decision on the underlying case without having that case in front of it. So currently there is apparently an ongoing case in the New Mexico 7th Judicial District Court where James Freeman's actions are being adjudicated. And in order for the federal court to declare, to issue declaratory and injunctive relief, all of that would have to be adjudicated in front of the again, the issue is going to go back to whether or not there is an opportunity to be heard. I think procedural due process is really going to be the key, not the deprivation of rights, of First Amendment rights. I think this is just trying to get it out of the New Mexico courts. It just doesn't make any sense why James Springer wouldn't be fighting this in the New Mexico courts, because that's where this should be fought. He's trying to turn this into a federal case, and it's not that I could see, not yet, not that he's alleged. Count 2, violation of freedom of the press and speech, First Amendment retaliation, including denial of the protected liberty interest in petitioning the government for redress of grievances. Plaintiff incorporates yada yada. Plaintiffs have protected the plaintiffs, plural. There's more than one plaintiff now. That was news to me. I've got to check. I'm sorry. I've got to check if there is now more than one plaintiff. No, there is still only one plaintiff. You never know. So Springer has a protected liberty interest in free speech, free press, and petitioning for redress of grievances under the First Amendment, made applicable to the states under the 14th Amendment. That's correct. Defendants Jason Jones and Susan Rosenthal have each undertaken retaliatory efforts. Now, these are the retaliatory efforts that Jones has taken. Jones issued threatening letters designed to chill plaintiffs' exercise of speech, press, and petitioning. So what he described was that Jones issued letters, threatening or otherwise, that said there's an order, the court has issued an order saying that you can't be here. Not what you could say or can't say, but you can't be here except on official court business and with a escort. It's just fucking weird. Yeah, isn't it kind of weird how James "We Don't Need No Government" Freeman goes to the government to get redress of grievances against the government. I remember I had a conversation with Freeman once. It was recorded and it's out there on the internet somewhere. But I was asking him, like, if you were on an island, a desert island with Bao, they were good friends back then. I don't know if they still are. Maybe they are. I said, if you were on a desert island with Bao, and it was a small island, and you had half and he had half, and he started playing just rancorously loud music all night long so you couldn't sleep. Wouldn't you want to have somebody like settle that, like, so you didn't have to get violent or anything? Guys are, oh no, I wouldn't even need to do that. Blah blah blah. I would get along just fine, and he could do his own thing, and as long as he's not like hurting me, then it's fine. And here he is. He hasn't been hurt. And here he is, like, it's all these guys who, like, we don't need the government. We could just as citizens do things. They all fucking run to the government. It's sad. It's just fucking sad. Rossigal refused plaintiff's statutory right to inspect public records, but the statutory right is not a violation of the First Amendment. To give false reports to the state police about plaintiff being an armed threat, endangering his life, again, that's not a violation of his First Amendment right. And cutting off his ability to petition the government by closing the office during normal business hours when plaintiff was present. But when was plaintiff present to petition the government? Was he there to petition the government? You didn't even allege that because he wasn't, right? I'll bet they don't allege that he was there to petition the government because he wasn't there to petition the government for redress of grievances. Upon information and belief, I don't know, all retaliatory efforts, including excluding plaintiff from defendant Murdoch Poff's public hearing, were undertaken at the direction and in agreement with defendant Murphy. So, which one of these two, Jason Jones or Susan Rosenthal, is he alleging excluded him from defendant Murdoch Poff's public hearing? Because previously he alleged that defendant Murdoch Poff excluded him from defendant Murdoch Poff's public hearing. Who knows? You don't know. I don't know. They don't know. Nobody knows. Only the shadow knows. Defendant's actions constitute deprivations of those rights out of retaliation for their exercise designed to chill a person of ordinary firmness from continuing to exercise those rights to speech, press, and petitioning. Plaintiff seeks declaratory and injunctive relief to halt these deprivations of his First Amendment rights. I don't know why he would fucking need that. Procedural. Thank God we got procedural due process. Oh, hallelujah, brother. Preach it. All right. Procedural due process. 14th Amendment to the United States Constitution forbids the state from depriving anybody from life, liberty, or property without due process of laws. No due process protections have been afforded to the plaintiff as required by U.S. Constitution of a pre-deprivation or post-deprivation process that allows for any opportunity, much less meaningful opportunity, to be heard and address the propriety of the government's actions. All fundamental rights comprised within the term liberty, including but not limited to the right to be free from bodily restraint, the right to contract and engage in the common occupations of life, the right to acquire useful knowledge, to worship God according to the dictates of one's own conscience, and to enjoy the privileges long associated with the rights of free people are guaranteed. Why are we talking about substantive due process rights? All you have to say is that he has a liberty interest in being in the courtroom or in the courthouse. The orders issued by defendants Murphy and Murdoch Poff, and the actions taken by Jones and Rossignol deprive plaintiff of his fundamental liberty interests in speech, press, and petitioning. That due process of law based solely upon discretion of the defense. Tell me you don't understand what the fuck a protected liberty interest is without telling me you don't understand what a protected liberty interest is. Procedural due process. Plaintiff had a liberty interest in being in the courthouse. Defendants denied plaintiff his liberty interest of being in the courthouse. Plaintiff did not receive from defendants notice and an opportunity to be heard, either pre-deprivation or post-deprivation. This motherfucker doesn't understand what procedural due process is. His fundamental liberty interests in speech, press, and petitioning. Count 4, violation of New Mexico Constitution, Article 2, yada, 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 as the 7th Judicial District Court. So again, this should get bifurcated because the only count against the 7th Judicial District Court is this. Well, yeah, the only count is count 4 against the 7th Judicial District Court. None of the other allegations are against the 7th Judicial District Court. So there are no federal allegations against the 7th Judicial District Court. And as far as I can tell, there have been no allegations made anywhere in here in the general allegations as to the actions of the 7th Judicial District Court, separate and distinct from the other people, or why there should be something different here. The defendant, 7th Judicial District Court, violated plaintiff's constitutional rights under the New Mexico Constitution, I'm going to guess, of freedom of speech, freedom of press, freedom of assembly, and due process, when that defendant entered the administrative order and amended administrative order attached here to as Exhibits 135, and when that defendant had those orders and letters attached hereto as Exhibits 2 and 4 served on plaintiff with no notice and opportunity to be heard. For the exercise of speech protected by New Mexico Constitution, Article 2, Section 17, defendant, 7th Judicial District Court retaliated against plaintiff by ejecting him from the public hearing on May 18, 2023, by denying him access as a member of the press to defendant Murdoch Poff's public hearing, denying him statutory rights to access access public records, and harassing with unnecessary and chilling law enforcement presence. Because defendant acting through its agents have violated plaintiff's rights protected by the Bill of Rights of the New Mexico Constitution, with disregard for the harm it would cause plaintiff is entitled to judgment, establishing those rights were violated, and for actual damages associated with those violations, as well as attorney's fees and costs. He's requesting a trial by jury of 12 persons. Well, counts 1, 2, and 3 would be decided by the judge. So it's only count 4 that would be decided by the jury. Well, it's a pretty shit complaint, I have to say. In the case, the defense attorney agreed to accept service on behalf of the individual defendants, and A. Blair Dunn managed to finally serve, allegedly correctly, the Attorney General of New Mexico for the 7th Judicial District Court. So the best attorney in the state of New Mexico has finally managed to get all the defendants served properly. And that was probably mostly because the attorney, Jay Delphin or whatever, agreed to accept service. Terrible. Anyway, I'm not really awake anymore. I'm tired of all this bullshit. I'm gonna, I don't know, do a little dance, make a little love, get down tonight or something. Anyway, thanks for watching. Thanks for hanging out. Have a good night.